of course, the appeal court sitting in Abuja, have discharged and acquitted, the former Chief Justice of the Federation, former Chief Justice Onnoghen from his case, because he was convicted for false declaration of asset by the Code of Conduct Tribunal, some time ago. Some of his properties were confiscated, or his bank account was confiscated. Of course, the case continued, but now the Court of Appeal has discharged and acquitted him. What does that mean?
Well, it's a good development, and we all know that the Court of Appeal, had 3 of his appeals in respect of the conviction and the sentence, and he was convicted in 2019, and while the proceedings were ongoing, he raised objections that the tribunal does not have jurisdiction to try him without first having a response to the National Judicial Council, which need to do what we usually refer as internal investigations and so on and so forth. Because a judicial officer, you can't just send a judicial officer to NJC and then to tribunal without passing to the NJC. So when after his conviction, recently we know that the federal government and the appellant had an understanding, and on the basis of that understanding, there was terms of settlement prepared, and the content of the terms of settlement, is that the respondents considered that the tribunal had no jurisdiction to deal with the matter without recourse to, the NJC, and it refers to some cases decided by the Supreme Court and even Court of Appeal on that point. And of course, we know that where a court has no jurisdiction, whatever the court may have done will amount to a nullity in law. So that was considered, and also they now agree that some of the terms be the judgment of the court, and that his bank accounts, which were to be forfeited on account of that judgment, be released to him, and he was discharged and acquitted. And those are the terms of the judgment, which were encapsulated in the terms of settlement, which means that now he's a free man, he is not an ex-convict, his accounts released to him, and it's a good thing because during the previous administration of President Muhammadu Buhari, the way some judicial officers were treated left a lot to be desired. For example, some justices of Supreme Court had their houses invaded at very odd hours of the day, like 2 a.m. They were invaded and on alleged corruption and so on. But at the end of the day, there was no single conviction. And then, after those incidents, the incidents of the former Chief Justice of the Federation, Onnoghen, came up, he was removed, and then he was subjected to trial by the Code of Conduct Tribunal, which convicted him and had his assets forfeited. And he appealed. He had 3 appeals, but they were consolidated. The 3 appeals were consolidated purposes of this judgment. So it's a good development. And now, when those things were going on, the average Nigeria perception about judicial independence, fairness, integrity were at stake. It was like the judiciary was on trial. But with this now, you discover that the man was painted black when he was not actually the way he was painted.
All right, Dr. Yemi,
yes, sir.
this recent acquittal of the former CJN, does it give credence to the fact that, of course, some people said that this was a witch hunt, by the executive? In fact, some people described what happened then as a coup against the judiciary. Does this give credence? Because, of course, some even lost their life. I could remember Sylvester Nguta. He was also one of the Supreme Court justices that was disgraced and embarrassed at that point in time. Some could not mentally, recover from that humiliation. And, of course, we have seen now that, of course, none of them was convicted. So does it give credence to those who believe that it was political? It was a coup against the judiciary, because this didn't happen prior to, of course, the CJN was about setting. He has already wanted to set up the 2019 the judges that will be taking care of the election petition at that before all of this happened. So, and
you see what has happened recently as to the issues the ex-CJN had was I will first of all say thank you to the present Attorney General of the Federation and Minister of Justice. I think he thinking deeply way of resolving issues. That is the way I categorize it. Because if not his office taking those steps and ensuring that those issues were resolved, we wouldn't have been able to say all these things we are saying. The said office had done the right thing. And the right thing done is that the errors made in the last administration have been corrected and laid to rest by the President and the General Federation and Minister of Justice. Because if you look at it from one angle, what has happened then is a kind of saying the judiciary has been invaded by politicians with their political strategies with a view to bring down the sector. But thank God with the development that area had.
Yeah, but was the judiciary actually invaded? Was it a coup on the judiciary?
No, the issue is this. Depending on your choice of words. You can say coup, you can say invasion. But the fact remains that there were some issues that made the judiciary to have been one way or the other embarrassed. For instance, invasion of residences of the serving justices. Number two, within a taking of an expert order, removing a serving CGM. It is somehow skeptical and funny. So now, be that as it may, all what had happened, but all what had happened then concerning that particular judicial officer had been laid to rest.
Yeah, but some people will say that it has not actually been laid to rest because, of course, there are some things you cannot.
No, you can't cry more than you believe.
You cannot whitewash.
No,
but what we are saying, what we are asking is what happened then? Was it the right thing? Looking at what has happened now.
One cannot cry more than they believe. A particular office took care of the appeal as respondent. And the two sides came together and said, these issues are resolvable issues. And the issues were resolved.
Yeah, apart from being resolved, yes, we are looking at the integrity of the judiciary as a whole, yes, and the integrity of our justice system. Yes. And integrity of separation, yes, of power, which, yes, we purport to practice, because these are the bedrock of democracy. Yes. We can't choose to tinker whenever we like. Yeah. So we are saying what happened then, what ought to have happened.
You see, the issue is this. The integrity of the judiciary, of the bar, of the bench is intact. With due respect, it's intact. But with politicians bringing in their idea, those ideas being brought that were used, that were strategized, worked for them one way or the other. But at the end of the day, with this development, those strategies became or become dead on arrival.
Yeah, but should the judiciary be a pawn in the chessboard of politicians? That's the question.
No, the issue is this.
That they could choose and to move the physics which way they want, and
no, that is not the law. But the fact remains that for every politician, they plan their game. But if you plan that game if that game is going on and it turns the other way around, you think back and you strategize, which has happened recently. Now, if the appeal goes on, or the appeal is going on, maybe from Court of Appeal to Supreme Court, what do you think will happen? Number one, wasting of resources, taxpayers' money. Number two, the prolonging of issues. But when you know that you have incurably bad case from day one, and it gets to a point that you discover that such issues should be resolved, why don't you resolve it to save the time of the court to save?
Yeah, of course the issue has been resolved. What we're saying is that if we applaud what this administration has done with respect to this case, should we not condemn what the past administration did with respect to that case?
No, what the past administration did, one way or the other, were not too fair. But let's be sincere. The present administration, having studied it, I said, okay, this is can't we go this way? And they go that way, and the two parties agreed. It takes it. Error made has been corrected.
So my contribution to that issue is this. I know that Nigeria practices democracy and constitutional one for that matter. And for that reason, whatever that is to be done by any of the arms of government must be in compliance with due process and rule of law. And the due process demands that before action is taken against a serving judicial officer, the normal procedure must be followed. And that was not followed in the case of the former CJN. Because what ought to be done is, there has to be a petition written against him, or complaint by any way complaint is lodged to the NJC. And then the NJC will now take up the matter, deal with it, and it is based on the recommendation of the NJC that the former CJN may be arraigned in court for criminal offenses, if any. But the executive arm of government just used law enforcement agencies and then did what was done in the circumstances without compliance with the normal due process and procedure. It is wrong. It is condemnable. And thank God the present administration has addressed that issue. Of course, I thank the courage of the current Attorney General of the Federation, whose office handled the matter, that considered that yes, we agree that the tribunal had no jurisdiction to handle this kind of matter. And to that extent, the appeal that were considered, they made an agreement, terms of settlement, and so on, that ended it. But then it's a lesson for everybody. If, like some people alluded, that those things were done to pave way for, some judicial officers to be given the opportunity to handle some election-related petitions or matters by the previous administration. Whether that is true or not is just of individual opinion. But the timing of what was done and the manner in which it was done, we know these things are wrong.
All right. So, Dr. Yemi, will you condemn unequivocally as a lawyer, because when the sanctity, of an institution which you belong, has been violated, it has a way to trickle down even to the least in that profession. Will you condemn what the previous administration did with respect to this case?
Well, what the previous administration done was not true, but the officers involved then, the political entities who were in office then, did not advise the government properly. That must have resulted in that. Because if you are in office, you are a people appointee, and your boss asks you, this is your view, it's what you advise that follow. So I believe the occupants of those offices then did not give accurate and expected advice, which is in line with the law, to the government resulted in such problems. As such, what was done then was unfair and not statutory.
So you condemn unequivocally?
Totally not acceptable.
You condemn that?
Totally not acceptable.
Do you condemn that?
I said it's totally, I said not acceptable.
Of course, you don't know it's not
It's a
acceptable.
matter of choice of words. It's a matter of choice of words. You can interpret it the way you like, but I said it's totally not acceptable.
All right, it's totally not acceptable.
Yes.
Okay, so moving on from that, now that the case has been quashed, has been
Yes.
acquitted,
Yes.
shouldn't there be a kind of punishment for those you said that did not advise the government? Well, of course.
I think I'm not
Should-
privy, I'm not privy to the documents filed before the.
No, you did mention that there are some people who didn't advise the government. Well,
Yes,
both the
there are some-
security
there are some-
agencies
there's-
who did the invasion,
Yes, but I'm
both
aware-
the attorney general who would have carried out this act,
The issue-
and now should this matter would just be settled and everybody go quietly to their abode? Given the fact that the public, this issue
The
elicited a lot of
public
public
interest,
opinion and public
yes,
interest,
yes.
it dented the image of the judiciary
Yes.
entirely. When the pinnacle of the judiciary, the CJN, was accused of corruption. He was stripped of his office.
Yeah,
It
yeah.
was like somebody was being stripped in the market square.
You see,
Shouldn't there
No,
be
you see,
severe punishment?
as a practicing lawyer, when you are preparing terms of settlement, there are some term conditions that would have been embedded in it, and I'm not privy to that document. So I may not be able to comment on it because I'm aware they must have addressed that area in the terms.
No, I'm talking about you. What punishment
My
you prescribe?
opinion-
Let's leave what they would have
no,
prescribed.
my opinion cannot outweigh the content of the terms executed and filed, adopted as judgment of the court. It cannot. So my opinion will have no place if the issues had been addressed. With due respect, my
Right.
opinion will have no place. But the fact remains that if you are preparing terms as a lawyer, as a practicing lawyer, there are conditions you foresee, which must have embedded there. But in most cases, the most important part of it is what goes.
No, the public might not be aware of it, but we're talking about as a lawyer with what has happened, with what you know about this case.
Yes.
What would, because of
If
course
it's
the government officials are listening.
Yes.
Perhaps they might take some of your, of course, some of the things we discuss here. They end up taking some of those things as recommendations.
Yes.
So what will you be recommending
The-
in your own personal?
Well, my recommendation cannot go outside the scope of the settlement rate. Because if I give recommendation that is outside the scope of the settlement, that is out of place. Now the fact remains that you see the persons who occupy those offices there were government appointees. They represented the government. They were to advise. They were to guide. Maybe they guided wrongly and they advised wrongly. Now somebody else to that office.
Shouldn't there be
occupy that-
consequence for guiding wrongly and advising wrongly?
Well, you may pass through code of conduct rule for that. The fact remains that somebody that occupies that office, which ex-predecessor was there. So, if you are preparing settlement result of that, those issues would have been put into consideration in order to base subsequent litigation.
Okay.
If that is not done, you just see a lot of suits in court will be filed.
Obviously,
But if those issues have been addressed, guided the case, it lays it to them. And that is why I say it is a finance.
Obviously, Dr. Yebi, you're being very careful with your words. We understand that. So, by so what would you say in issues like this? Should there not be, so that to forestall a repeat? Because the judiciary, as we know, shouldn't be a playground for political strategies during election. It's a state institution that should be respected. Of course, terms of settlement has been, but the damage has already been done. It's almost like a medicine after death because the public perception has already been created.
Yes.
So what will you,
Well, the issue is such that the first thing that has been done now is that the convict has now been, the conviction of the former CGN has now been quashed. It's no longer an ex-convict. And then some people have the view that what has been done is not full justice, that is half justice. That there ought to be a way of compensating the man for the damage done to his integrity, his good name. And in fact, one observer, advised that he should sue President Muhammadu Buhari for criminal defamation and all that and all that. But then I believe that so far, now that the matter has been laid to rest, steps need to be taken to forestall a repeat of such occurrence. And then it also lies on the former CGN, who at least whose name has been cleared and whose bank account has been restored, to decide whether he wants to pursue action for damages outside the terms of settlement that had to do with the criminal charges before the court.
All right.